Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3077. United States of America versus Derrek B. Arrington, appellants. Ms. Wright for the appellant, Mr. Cahill for the appellate.
Good morning, you may proceed.
Good morning. May it please the court, Lisa Wright for Mr. Arrington. I'd like to reserve 2 minutes for rebuttal. The district court's imposition on resentencing of a 65-month upward variance from a guideline range of 140 to 175 months to the statutory maximum of 240 months was procedurally unreasonable in 3 independent respects. To quickly summarize, the court treated Mr. Arrington's post-sentencing rehabilitation as not relevant to the court's sentencing task. The court justified the 65-month variance in part on the shooting of Officer Daniels when the gunshot had already been accounted for, as the court conceded, and the court failed to explain how the wrongfulness of inflicting that gunshot made Mr. Arrington worse than the typical defendant. And last, and where I'd like to start, the court justified the 65-month variance in part on the theory that the guidelines provided no punishment for the illegal and stolen nature of the gun, when the government has conceded that but for the illegal nature of the gun, his guideline range and his sentence would have been capped at 120 months.
Let me start you back a little bit. So what's the status of his parole revocation? Because he served his sentence.
He is serving on the parole revocation now.
Okay, and you believe that this impact, if we were to rule with you, would take 65 months off of his sentence?
Well, it would require,
Not off his sentence, but
if any of the errors we're pointing to are affirmed or correct, then the 65 months would not be justified, would need to be a resentencing, because part of the justification would have been invalid for any of our 3 reasons, any one of them, because they all work together to create the 65 months variance. And if there's an error in it, it needs to go back to see what variance Judge Lamberth might impose.
Well, and some of your suggestion for how you get there is a consideration of the post-rehabilitation factors.
Right.
But that is something that a court may consider, correct?
Well, this court, I believe in Hunter, said that if the argument is non-frivolous, the court has to consider it. And here, the court, I think, had a misconception. He said it quite plainly. As he viewed his task, quote, "I'm not sentencing the guy that's appearing before me today. I'm doing what I think would have been the sentence Judge Robertson would have imposed were you there then." And this approach not only used a benchmark, used as a benchmark, a judicial decision that was based on retroactively unconstitutional guideline range, plus, other.
But the rest of the quote says, "I have to sentence you with what I have today." So do you not think that despite what might have occurred earlier, you're relying kind of on one sentence and not the totality of the record?
Well, it's a pretty blatantly incorrect way to look at it. When he says
actually it's correct, because he's sentencing the defendant on the basis of the evidence that existed at the time of the original trial and sentencing. I mean, that to me is what he's saying. Of course he has to do that.
Well, he says, "I'm not sentencing the guy that is appearing before me."
Yeah, I know. That was after he said, you're not young anymore. Isn't it? I mean, that was the
he is.
You're not young anymore. You're mid-age. It's been 24 years since you committed the offense, so you're not the same person.
And he says the progress you've made is a good sign. You're on a different path. You're not that person anymore. And then he's saying, but don't let what I'm saying about this sentence set you back, because even though I find that you are different, I'm not sentencing you as you stand before me.
There's a whole line of cases, the Supreme Court included, that say you don't read an opinion as if it's a statute. And there's a comparable line to say that in oral presentations of reasons for giving a particular ruling, you don't read it as if it's an opinion that's been parsed and massaged.
Well, I don't think there is ambiguity in the court's words, and the government acknowledges that Judge Lamberth gave no weight to this reason. And I don't think you can presume the error away in a case like this, because it was a very unusual case. It wasn't a typical resentencing. It was like a lightning strike situation where the Supreme Court, which never happens, makes the guidelines retroactively unconstitutional. Judge Robertson, through no fault of his own, never had a chance to give a constitutional sentence. And I think it was understandable that Judge Lamberth felt like he was taking Judge Robertson's place, but you can also see.
Shouldn't the starting point be the statement of reasons that Judge Lamberth gave for the sentence? You start with the colloquy or the back and forth in the oral pronouncement. But shouldn't the starting point be the written statement of reasons that he gave?
Well, I think the oral statement is what, they both factor in. But I mean, what he told the defendant.
Under the statute, he has to give a written statement of reasons.
He has to do both. He has to do both.
And in his written statement of reasons, is there any indication that he erred?
Well, yes, for my other reasons, I'd like to talk about.
I'm talking about the rehabilitation.
Well, in the written statement of reasons, he's simply saying, these are the reasons I'm going down. And he doesn't talk about, I'm just pointing out that in making those findings, he didn't consider this counterweight that we presented. We argued this rehabilitation is relevant, and he essentially ruled because of the way, he saw it as it appears that he was trying to give deference to Judge Robertson, saw himself as taking Judge Robertson's place, but got the timing a bit confused. And I think, it's understandable.
Just on the rehabilitation point, the Pepper case, as I read it, says that the court may consider rehabilitation in determining whether to make a downward departure. Judge Lamberth wasn't going to make a downward departure. He made an upward departure.
Well,
so Pepper kind of drops out of the picture, doesn't it?
Well, I think the point is when weighing, you, and I think this court has said have to, if it's not a frivolous argument, if something points down, you have to consider it, and it points down whether you're giving an upward or a downward variance. But I'm happy to move to talk about
So what I would want to know is, what would you instruct us to do if we were to remand? What would you have us instruct a new district judge?
I would have the court say that there was error in the 65-month variance, so that 240 months needs to be vacated and remanded for resentencing. And that's not saying Judge Lamberth couldn't still give a variance. Theoretically,
when you say variance, not to say that he wouldn't still upward vary.
You
understand?
Right. But
resentencing, you take a risk.
Right. But some of his reasons are infected with error. And we don't know if he had not made these errors, if he would have given 65 or less.
So if we were,
Go ahead.
if we were just focusing on the rehabilitation issue, is the remand, I just want to make sure I understand what the error is in your view. Is it at bottom, he was supposed to consider Mr. Arrington's character today at the resentencing rather than what he thinks his character was in 2001? And so you have to,
I think it's just sort of
rehabilitation towards
essentially, but I guess I would put it as far like, given that he's rehabilitated, that weighs into the 3553 factors, like his history and characteristics. And
that's what I'm getting.
Yeah. And if that was the only error, then I guess there could be a remand to weigh that. But I think there's these other errors that contributed to an amount.
If that was the only error, can you give us your best argument that was prejudicial?
Yes.
By not considering his rehabilitation by 2024, that might have changed the outcome?
Yes. So I guess the government has argued, I don't think the government has argued that this error is harmless. But it's not harmless in light of the rationale about the shooting. because as we talked about in the brief, when Judge Lambert said I would give the maximum because of the shooting, that statement was infected with this misunderstanding that the injury had not been accounted for. And then when it came time for the statement of reasons, the court withdrew that part of the justification, that premise for his statement that the injury, and just relied on sort of the general wrongfulness of inflicting the injury. And so that statement really no longer stands. And again, I guess the government does say that the shooting alone called for 65 months and that therefore the rehabilitation isn't harmful, but the rehabilitation is a counterweight to that. So even if it's true that the judge thought it called for a full 65, he didn't consider something that pushed the other direction.
Well, but the thing about what you're saying, embedded in your comments is a suggestion that just because somebody has rehabilitated, they automatically get that consideration, when part of rehabilitation is so that you become a productive model for society. That should be something that you do. It's almost like your child doing well at school and they want so much credit for that. That's what they're supposed to do.
I understand, but not everyone does. And so when the court has an opportunity to resentence someone years later, it is relevant and it's been found.
But also embedded in your suggestion is that we don't look at how egregious the conduct was in the first place. Sometimes it's just really bad, just like when people come before me, being sentenced as a former district judge, and they committed murder as their first offense. And then the defense counsel argues, oh, they have no prior record. Is it murder bad enough?
Well, I understand that it's up to the court to weigh. The problem here is the court didn't give it any weight because of this misunderstanding that it wasn't relevant. He was conceiving his task as putting himself back. And I think the evidence of that.
He never said it wasn't relevant.
He said, I'm sentencing the person back then.
Yeah, we've been over that ground. One thing I want to comment on, you mentioned in passing with respect to the question that Judge Garcia asked about harmless error, that the government never argued it. Harmless error. There's a case, the law of the circuit is that the government can't waive harmless error because it's for the benefit of the judiciary and our process. And the case is United States versus Price, PRYCE, in the early 90s, in an opinion by Judge Williams.
Well,
so you're not claiming that the government waived?
No, I'm not saying they waived it, but and they do say, I want to correct, they do say that that because the court said the shooting justified the maximum, which is a flawed statement that the court essentially retracted in part. But they don't deal with the fact that this is a counterweight. So even if you thought that was true, that he thought that, he still didn't consider something. I wanted to say that some evidence of the fact that the court thought he could not do that it was irrelevant, is the fact that he went back to determine the sentence and came back out from recess said he had determined the sentence and he had not invited any allocution for Mr. Arrington, which
the probation pre-sentence report didn't recommend a downward departure because of rehabilitation, did it?
No, and they didn't. I don't believe it recommended an upward variance either. It said no grounds, I believe. Right. So this was coming out. But I think if the judge was taking into account, I'm not saying, Your Honor, that he can't say he's not persuaded by it. Mm-hmm. But it seems here he made a legal mistake. But if I can turn to the error about the illegal nature of the gun, because the government there has conceded that the court's finding that the gun count was effectively dropped out of the sentencing calculation was erroneous. The government acknowledges that the gun did not entirely drop out, quote unquote, and that but for the gun count, the guideline range calculation of 140 to 175 would have been capped at 120, meaning that the gun count effectively added 55 months to the guideline range. on count one. And the court said that the count one offense level didn't account for the illegality of the gun. But without the gun count, the count one offense level could not be effectuated. And in that sense, it did affect the offense level of count one. So the illegality of the gun did add 55 months of punishment to the punishment for the assault. And the court was wrong in thinking it wasn't specifically accounted for as independent, wrongful conduct. And the government tries to get around this by spinning the record and saying that the court made a finding, quote unquote, that merely increasing the applicable statutory maximum did not fully account for the gun contact. But the court did not make any such finding or anything close to it. The court said nothing at all about the gun increasing the statutory maximum, let alone whether the resulting increase, 55 months, was enough to, quote, fully account for the gun itself. The court was focused on the technicalities of the offense level calculation rather than on what conduct was leading to what punishment. So because the 65-month variance was based in part on an erroneous understanding of the illegality of the gun had contributed nothing to Mr. Arrington's guideline range, when in fact it had already contributed 55 months, a remand is required on that basis alone. And we also believe, if there's no questions about that,
All right, well, we'll give you your 2 minutes in rebuttal.
thank you very much.
May it please the court, Timothy Cahill for the United States. The district court did not commit any procedural errors in resentencing Mr. Arrington, therefore a remand is unnecessary in this case. Judge Lamberth did not plainly err by declining to afford weight to Arrington's post-sentencing rehabilitation, particularly under the specific circumstances of this case, where Arrington had already completed his maximum term of incarceration. Now, we acknowledge that in his oral statements, Judge Lamberth, some of his language may have been inartful, but in the context of the arguments that he was presented with and was ruling on, we submit that the most reasonable interpretation of them is that he was explaining that he would not afford.
So before we talk about what he actually said, can I just understand your view of the law? So the very first 3553A factor is the history and characteristics of the defendant. If the judge had said, I'm not looking at your history and characteristics today, I'm looking at your history and characteristics as of 2001, is that an error?
If there was nothing under the circumstances of the case to justify that, I think if he just flat out indicated that he believed as a matter of law that he would not be looking at anything after 2001, then I think that would be counter to Rhodes and to Pepper.
Okay. And so your next argument is, but the sentence was completed, so he didn't have to look through his history and characteristics today.
So in any particular case, I think that a key distinction I want to draw here is whether a court needs to consider an argument versus whether they need to consider a factor. So someone made an argument about whether a factor is relevant or not, but a court can decide, having listened to the arguments about that factor, that under the circumstances of a particular case, that factor doesn't bear any weight. That factor doesn't bear weight on the outcome of this case under these circumstances.
I think everyone agrees that if what the judge had said was, I hear your argument about rehabilitation, but that's outweighed by your criminal history and your actions, that would be fine. And then the next question would be, what if he just said, when your sentence has ended, your current characteristics are categorically irrelevant, which seems to be your argument.
I think if that was his basis and he explained that was the basis, I think that's largely how we read his decision in this case. I think there's more than just that the sentence ended. I think there's also factors that the government had just argued to him about the fact that that was a sentence imposed by another jurisdiction. That jurisdiction had opportunities to review that sentence and had declined to reduce it. I think all of those play in here. I think our key is that under those particular circumstances here, including the fact that the sentence was fully completed, that he declined to afford weight to that factor, that was within his discretion to do, that was legally permissible and within his discretion. And that's how we read his comments.
So you don't think he said, I'm not looking at the person in front of me today and his character.
I think there's tension within his statements. I think he makes statements about Mr. Arrington being on the right path and sentencing the person who committed the crimes back in 2000. Then he also says immediately after that, I have to sentence you with what I have today. I think there's ambiguity in what he said. And given that ambiguity, we look, I would refer to the Kenny decision that we cited in our brief, where taken in isolation on its face, the court said, the sentencing court said something about sentences have to be consecutive, which was incorrect under the guidelines. And this court declined to read that as an error of law, just taking that sentence, that fragmentary comment in isolation. It looked at the entirety of the comments. It looked at the arguments the parties had presented. It looked at the nature of the ruling and said, we don't read this as an error of law. In the context of what this judge was saying from the bench, we read this as the judge making a discretionary decision. And we would
But your version of his discretionary decision was that on the facts of this case, the defendant's current character is irrelevant.
Certainly that it didn't warrant a reduction, that it didn't bear on his on reducing it because he had already served his entire sentence. Because to the extent that he was serving a sentence imposed by another jurisdiction, the court was going to decline to expedite that, where that other jurisdiction had declined to do so. So I mean, those were the arguments. Sorry.
So my one question I have is, what you're saying makes perfect sense if we only think of his rehabilitation as relevant to the need for incapacitation for recidivism purposes. That's entirely about the ongoing incarceration on a separate crime. And I understand your argument on that. But that's why I started by saying the very first factor is not the need for incapacitation. It's look at the history and characteristics of the defendant. And what argument is there? I'm struggling to understand the government's argument that you don't look at the history and characteristics of the defendant in front of you here today. I mean, the sentencing memorandum, more than half of it is about exactly this. It's my character has improved. And then at the end, there's a short section about, and you don't need to worry about recidivism. But it's look at my characteristics today. And if the court didn't do that, why isn't that an error?
And so again, we read Judge Lambert's comments as not saying that he didn't even look at that. In fact, he clearly did look at it because he commented on it at the trial. It did not escape his attention. But whether or not he determined in this particular case, whether or not that bore any weight on the outcome of his decision. So I recognize that, the 3553A factors are something the court needs to at least look at in every case. But in our brief, we cited case law. And in fact, the statute itself suggests that just because the court has to look at those factors doesn't mean that they will have a bearing on the outcome, on the sentence. In a particular case, the court might say, under these circumstances, that factor does not affect the sentence I am imposing. And as long as there's a reason for that within the court's discretion, that wouldn't be a legal error or an abuse of discretion. And our interpretation of Judge Lambert's comments on the entire record is that that's what happened here.
And if I start from page 259, where he says, because I would presume Judge Lambert knows the law as you're setting it out. And if I start on page 259, where he says, I'm not sentencing you, the person in front of me today. I'm sentencing you as if you were the person in 2001. Where do you want me to look in the transcript to persuade me that he actually did consider his current character?
I mean, I would say the very next sentence is I have to sentence you with what I have today. And I acknowledge there seems to be tension between those two. And that's why we look at like I said, we look at the arguments he was responding to. It wasn't that these issues weren't fully fleshed out. They were in both the briefing and the arguments before him. And that's how we read his comments.
And he also said, of all the young guys I've sentenced, it's when they were young, you're not that person anymore. And I took that to mean that he's aged.
I think there's no other way to read his comments than that he is responding to what Mr. Arrington's attorney and Mr. Arrington had spoken about, his efforts at rehabilitation. The judge is commenting on them. But I think ultimately he made a discretionary decision that under the circumstances here, that did not warrant a reduction.
And the other point that you made is that there's another case in this circuit that we decided where Judge Lambert specifically took rehabilitation into account to reduce the sentence.
I think that was the Hunter decision. I think he actually did not end up reducing in that case, but he fully and more expressly, certainly more than he did on this record, I'll acknowledge, more expressly considered. And he properly applied Rhodes and the Rhodes decision, and this court affirmed and indicated that his analysis was correct. And so we don't even just have to deal with the presumption that judges know the law here. We have a published opinion saying that this court affirmed Judge Lamberth for correctly applying the very law that's at issue here. And that's why we view, to the extent that there's tension in his comments, we view them as his inartful language, not as an error of law. I did also want to respond to the other argument that was addressed during the appellant's argument, which is about the consideration of the felon in possession stolen gun charge. I wanted to make absolutely clear the government does not concede that there was any error by Judge Lamberth here. To the extent that we acknowledge the statutory maximum played a role in the sentence, that does seem to be an obvious statement of law. The statutory maximum plays a role in every sentence. In determining the appropriateness of a variance, the proper benchmark is the guidelines numerical range, which attempts through the application of categorical rules to measure an appropriate term of incarceration based on specific conduct in a particular case. So if a judge is varying from that, it's got to be based on factors that were not captured by those numbers. And with respect to that numerical range, Judge Lamberth was absolutely correct that Mr. Arrington's felon status and the aggravating fact that the gun was stolen did drop out in the sense that they played no role in determining the numerical range that he was looking at and that he was varying upward from. And we would submit that that's the appropriate benchmark that he was referencing, certainly in context, not the statutory maximum. If there are no other questions from the bench, we would otherwise rest on the arguments in our briefing and ask that the judgment of the district court be affirmed.
Thank you very much.
Thank you.
On that last point, I think Mr. Cahill is saying that the error played no role in the numerical range, only the statutory max. But when the statutory max is less than the range, I think it's 5G 1.1 or 1.2, they talk about you have to limit the range. So the range but for would have changed from 140 to 175 to 120. So it did affect not just the range, but the sentence. And I think he also said the stat max is always relevant, but it's not always relevant because it doesn't always bump up against the guideline range. So this case is different. On the thing Judge Lamberth said about, I go with what I have today. Again, I think what he is saying there is I'm putting myself in Judge Robertson's place. I want to defer to him. You never got a constitutional sentence. Judge Robertson never had a chance. Now I have to figure out what Judge Robertson would have thought back in 2001 if you were there then with this new legal information. And to do that, I only have what I have right now to figure that out. I think that's all he's saying there. And I just don't think you can read this sentence as not categorically refusing to give weight to the.
But you also don't have on the record that he explicitly stated, I cannot consider the rehabilitation. Like you don't have any affirmative statements that indicate he explicitly did not consider it.
I mean, to us, this is explicit, I guess I would say, because that's what the rehabilitation is about, is how have you changed between who you were then and who you are today? And that's what he says. He's got it backwards there. And I do think, again, yes.
But even then, it's a may, like you can weigh it, but you can also discount it.
True, but right. But here he's legally essentially putting it out. It's not just not relevant, which is different than saying I'm not convinced by it or it's outweighed by other things. We agree he could do that, but that's not what he did. And I think unless there's other questions.
Okay.
Thank you.
Thank you as well.
Case number 24-1348. Ryan J. Paul, petitioner versus Federal Aviation Administration. Ms. Banya for the petitioner, Ms. Lilly for the respondent.
May it please the court. I'm Stephanie Spagna, and I'm here on behalf of the petitioner, Ryan Paul. The FAA has disclaimed any authority to review Amerijet's determination that First Officer Paul had supposedly refused a random DOT FAA drug test. The FAA's position is insupportable as a matter of regulatory interpretation. It is in direct conflict with the FAA's own orders directing it to investigate whether a refusal actually took place. And it also violates Mr. Paul's due process rights. Even if the FAA were somehow correct that DOT regulations actually prohibited from reviewing an employer's refusal report, this arrangement clearly violates
So
the
you don't dispute that you can send something to a third party for conducting of the drug test, let them make a determination. Your dispute is about whether the FAA stays in control of that decision.
That's essentially it. Yes, Your Honor.
Okay.
Yes. And so our position also is that this arrangement clearly violates the private non-delegation doctrine because a private entity and not the FAA is exercising the final decision-making authority as to whether an employee committed a regulatory violation by refusing to submit to a random drug test. In response to a point that the respondent raised in their supplemental brief, the employer's task here is not simply ministerial. It's not a matter of adding numbers and stamping paper. It's not a matter of making recommendations that the government can accept or reject at will. It is actually exercising a decision. It is determining that the pilot has refused the drug test, and from that decision, very severe and permanent consequences flow. That pilot is immediately barred from holding a first-class airman medical certificate for 2 years. And then even beyond that, that pilot will be marked as a rule violator and a substance abuser in the pilot records database. And if the pilot
Can I
wants...
ask you to clarify something you just
Certainly.
said? I think you just said this finding revokes the airman certificate.
Oh.
That's not true, right?
No. And
It means that
if I
it's disqualifying for a future application, which is slightly different.
Oh, yeah. Pardon me if I misspoke, Your Honor. I meant to say that he is barred from holding an airman medical certificate, which is different from just an airman certificate per se. So he cannot hold a medical for 2 years, which means that he cannot fly. And then in addition to that, he will also be marked permanently in the database as a substance abuser and a rule violator. And that's an extremely severe stigma and scarlet letter on his record for the remainder of his aviation career. And because the FAA has given the final authority to the employer, the private entity in this case, Mr. Paul has no recourse. There is simply no means for him to get to have the employer reverse their decision or modify this. He's stuck with it forever.
What do you take to mean on the August 27, 2024 letter about FAA saying not taking any legal enforcement? Like what weight or what suggestion does that do to make it beneficial to Mr. Paul as the FAA claims?
Well, the FAA declined to take enforcement action against Mr. Paul's airman certificate, which is a very serious action, which would have been, had they done that, would have been appealable to the National Transportation Safety Board. They elected not to do that. And I think we've made clear in our filings that we are not challenging that portion of their rule violation finding. We are challenging that finding to the extent that it adopts and incorporates and accepts as given the employer's report that he refused a drug test. And
If it
from,
had gone to the National Transportation Safety Board, sat on cases dealing with that. They hold evidentiary hearings, don't they?
yeah, essentially, Your Honor, the absolute worst thing would have had to have happened to Mr. Paul for him to have had a chance at having the underlying refusal report reviewed. But since the FAA,
Before the board, would it have been de novo? On the question, did he refuse?
On the question of, to be honest with you, Your Honor, I don't have an answer to that question, but I would be happy to supply a letter to that
They
effect.
do conduct evidentiary hearings.
Yes,
The
yes.
board does.
Yes,
Right.
yes. So conceivably, they could have at that juncture have reviewed the merits or lack thereof of the refusal report.
So the thing that makes this unreviewable is the fact that the FAA took, quote, no action.
They took no action with respect to his airman certificate.
Right.
That is correct. But they accepted without question the employer's report that he had allegedly refused to test. And from that, the legal consequences flow. That
One more question.
Yes.
It's one thing to say that you have the responsibility, Mr. Employer, to make the judgment about whether there's been a refusal or not. It's another thing to say whether that judgment is reviewable. Could he have sued his employer on the grounds of whatever grounds that the consequence is harm to him? And so he brings an action against the employer to get that refusal finally revoked.
Well, Your Honor, the regulations preclude him from being able to get relief from those consequences against the employer in an arbitration or in any other forum. He simply has no means whatsoever.
Are they cited, the regulations cited in your brief?
Yeah, yes, regulation 49 CFR 40.191C. The regulatory consequences can't be overturned in an arbitration, grievance, state court, or other non-federal forum. And so unless he was able to persuade somehow the employer to change its mind, he's stuck with this. And
I looked at that regulation and I was a little confused because the one thing it doesn't say, as you just said, it says non-federal forum.
Mhm.
It doesn't say you can't sue in federal court. Has anyone ever tried that?
I'm unaware of that, to be honest with you, Your Honor. So, yeah. And my sense is that this is a fairly unique case on its facts.
I had one clarifying question also. One of the immediate consequences of this determination is you're prohibited from flying until you complete the return to duty process, correct?
That's correct, yes.
What is your understanding of how long that process usually takes? And I'm sure it varies case to case.
I think it varies significantly. It can be a few months to longer. I don't think that there's a hard and fast rule. I do want to clarify, Your Honor, thank you for that question, that we are not challenging the fact that if there is a legitimate report of a refusal, then a return to duty test ensues. We're not challenging that fact. What we are challenging here is the fact that the FAA has essentially rubber stamped the employer's determination. And as a result, Mr. Paul has a scarlet letter and currently is unable to earn a livelihood in his chosen profession.
If the regulations preclude the relief that you're seeking and the statute does not grant that relief, what is the basis for our court saying that he's entitled? Is it due process or is it a violation of the statute or what?
Well, yes, Your Honor. Thank you for the question, Your Honor. We've argued this on several grounds. First, that this was arbitrary and capricious on the government's behalf, and in part because it is sought cover for essentially washing its hands by pointing to an inapposite regulation. 40.355I speaks only to the respective responsibilities of an employer vis-a-vis a service agent and does not speak at all to the authority of a reviewing agency.
But that leaves the question, what
Yes.
regulation does speak?
To the FAA's ability to review.
Right.
Our position is that that is inherent in the FAA's role as the agency which is to which this employer is subordinate.
But there's no regulation that gives them explicit authority to review or refusal, right?
There's, in terms of review, I am not able to recall one in particular at this moment, Your Honor. I will say that that what the FAA did not do here was to comply with its own order, calling for it to actually conduct an investigation as to whether he actually had refused a test. And so, if this court were to rule in Mr. Paul's favor, then, and the appropriate remedy in our view, and which we have requested, would be that for the court to vacate that portion of its rule violation finding that Mr. Paul had refused the test, and then go forward and conduct the investigation that its own order said that it should have conducted in the first place.
With respect to you making a suggestion that the FAA just rubber stamped the investigation, the information about Mr. Paul with respect to his vacation leave, his illness, was available before the August 27, 2024 letter by the FAA?
Yes, that is correct.
So then it's obviously available at the point of reconsideration as well.
Yes, that information would be available then. Yes, Your
So
Honor.
when I look at the report of the FAA, it doesn't look like that information is all included in this timeline that they provided about the investigation.
Could you, I'm not sure that I understand your question, Your Honor.
Well, their investigative report, it doesn't
Yes.
look like all of the information that Mr. Paul was presenting is included. It suggests that it was all considered.
Yes, yeah, that's correct. Yeah.
Okay. All right, thank you.
Thank you, Your Honor.
Let's save some time for rebuttal.
Yes, thank you.
Good morning, Your Honors. Jamie Lilly for the FAA. I'd like to start by focusing this court on the action that is under review. Here, Mr. Paul has petitioned for review of the agency's decision not to take enforcement action against his airman certificate. That enforcement action was fully within the FAA's control and was fully favorable to Mr. Paul.
You say favorable, but if you look at the wording of, and you're referring to the August 27, 2024 letter?
Yes, Your Honor.
It says, "We have concluded our investigation into your refusal."
Yes.
And it goes on, "We are not taking any legal enforcement action against you in connection with your refusal." So while you say there's no enforcement action, to me, this reads as if you're agreeing that there was a refusal to submit. So then there's a negative implication on his record regarding that.
If I may address
Sure.
both of those separately. So the enforcement action that is reviewable in this court and that FAA may take is a decision to suspend, revoke, place additional conditions on his airman certificate, basically his license to fly a plane.
Yeah,
And
but when you say no enforcement action, it makes it sound like he's clear, like you're agreeing that
With
there's
respect-
nothing that he needed to have done.
Yes, Your Honor, with respect to
He does
his,
have some duties that he needs to complete on a refusal to take test action that gives him, I guess, up to 2 years to get that done.
thank you, Your Honor. So
Okay.
that is a separate requirement that is imposed by DOT regulations. And if I can talk about exactly what's required there, when an airman has been deemed or reported to refuse to not complete random drug testing, that information gets sent to FAA. And by operation of DOT's regulations, the airman must do something to demonstrate that he is safe to fly. That's what the return to duty regular process is. He meets with a qualified substance abuse professional who then requires additional testing. So that is all that is required by the
I'm just
return.
confused about no enforcement action to me conflicts with he refused duty.
Your Honor,
Like, how are you helping him out? How do you deem you saying that is being beneficial when you're now telling me all these things he needs to do?
the FAA has said he may use his airman certificate. He can
He can use it now.
He can use his airman certificate. Separately, in order to use it, there are lots of conditions on using your airman certificate. You've got to submit to random drug testing. You've got to, maintain all sorts of certain standards. Here, the random drug testing was not completed. And so as part of DOT's regulations, when that happens.
But it's a difference in not completed versus refusal to take tests.
Your Honor, I think
Seems like that's a negative implication. Not completed could be, we just couldn't get our time straights about our appointment times or something like that.
Well, Your Honor, the regulations kind of define what refusal means, and failure to show up for a drug test is a refusal, a failure to complete. And when you haven't completed your random drug test, DOT sensibly says, before we put you back doing safety sensitive functions, we want you to complete that drug test. And the way that we ask you to do that.
In fairness to you, in your supplemental briefing, it says upon receiving a report of a refusal, the FAA investigates.
Exactly.
And decides what enforcement action, if any. So what do you deem as your investigation? Because it doesn't seem to include Mr. Paul's side of the story.
Your Honor, FAA completed an investigation. It took 4 months into the circumstances surrounding his refusal, received the report of the refusal.
Does that include conducting any interview with him?
Your Honor, I don't know. They haven't. I don't think petitioner has raised that as an objection. He was allowed to submit any information that he wanted to the FAA as part of its enforcement investigation. And then at the end of that, the FAA said, I've looked at all this information and you're free to go and use your airman certificate. Now, one of the conditions of airman certificates is submission to random drug testing. And in this case, where it's not been completed, the FAA the DOT sensibly imposes the requirement that where there's been a reported refusal, an incomplete drug test, that you complete the drug test after you meet with a substance abuse professional.
So why you're framing this as though this letter just says, congratulations, we're taking no action against you. Mm-hmm. But his response is that you should read this letter as saying, you've asked us to review your employer's determination that you refused a drug test. We are not doing so. Also, we are not taking further enforcement against you. That is how you describe the letter. The FAA does not review the employer's determination there was a test refusal, and he sought our review to say that aspect of the order violates the law. So why is that not the way to think about what's going on here?
Because the operative agency action is about whether he's safe and can continue flying planes. And the relevant considerations are the report of the refusal, investigation into the circumstances around the refusal. And FAA's ultimate determination is not about a refusal, but whether he can continue flying planes using his airman certificate. And they determined,
and his
yes,
argument is that is the legal problem in the case, that you don't go and check in any way whether the employer correctly determined that he refused a drug test. And so he says there's a private non-delegation and a due process problem if you don't do that.
Your Honor,
and
the FAA did in fact investigate the circumstances surrounding the refusal. That was the point of the investigation. There was a report.
You didn't know if they interviewed him. Like, what is the investigation?
The drug abatement division of the FAA, under the supervision of the federal air surgeon, conducts an investigation receives information from the employer about the report, receives information from Mr. Paul. I think he made at least 2 different submissions of information around the determination and the circumstances. And The result of the investigation was FAA's decision that he could continue to use his airman certificate. And then separately, DOT regulations say you need to take a drug test. And
Well, that's not, right.
where you haven't taken one.
Point 285, whatever that 40.285 says, as you're reading it, says when your employer decides that you refused a drug test, you can't fly planes. You could before, but when the employer makes that determination, automatically you can't fly planes anymore until you complete this process.
Right.
And the FAA never reviews that determination.
Well,
right.
Your Honor, I think we've explained before the FAA does review that determination to determine whether you can use your airman certificate. But what it says is
it does never, the whole problem, if there is a problem in this case, is that he's in a black hole. He's saying, I would have gotten review if you took a harsher action against me, but you didn't take action against my certificate. And the result is no one ever double checks whether the employer had any basis to find I refused a drug test.
Your Honor, the question is whether he is safe to fly planes and can resume safety sensitive functions. The way DOT has determined that the appropriate way to do that is to ask him to take another drug test under the supervision of a substance abuse professional. Haven't taken a drug test, haven't complied with the random drug testing requirements. So we say, please take another drug test under the supervision of a substance abuse professional. Then if you've satisfied those requirements, you tell the substance abuse professional, exactly the circumstances around this, the refusal, and that person determines that the appropriate course is to take another drug test or perhaps have some counseling. You could be back up in the skies before FAA has completed its investigation into your.
Even if the FAA, if I understand your point, even if the FAA reviewed the record and found that he didn't refuse, he'd still have to take a drug test because he was due to take one.
Right. He hadn't taken a drug test in response to the random drug testing. And so the FAA or the DOT's return to duty regulations provides a process for him to do so and prove that he's safe to fly.
Can I ask you to respond to, so one of the arguments, assume there's nothing in the statute or the regulations that says the FAA is going to review this kind of thing. Mm-hmm. They argue in their brief that this order, the guidance, does promise that.
The handbook.
And order 91.E, whatever it is.
Yeah.
And I don't think you all addressed that in your brief.
Yeah.
So I was hoping to hear a response.
Thank you, Your Honor. That's the Drug and Alcohol Compliance and Enforcement Surveillance Handbook. So the internal guidance to the Drug Abatement Division and others who are conducting investigations into refusals. And it's fully consistent with exactly what we're saying here, that FAA's Drug Abatement Division, when it investigates whether to take action against an airman certificate, looks into the circumstances of the reported refusal.
Right. And one of the things it says is the purpose of these investigations is to determine whether a finding of noncompliance exists. And what Mr. Paul says is that is saying you are supposed to find out if he didn't comply with the regulations. In other words, whether he refused a drug test.
I think those may be different things. The employer reports factual information about a report of a refusal. The agency's determination is whether that fact, along with other facts surrounding the reported refusal, warrant legal enforcement action. So I think that's
completely understand that's the FAA's position. Their position is that this says we will review to determine whether a finding of noncompliance exists, and that we should read that to mean, no, actually the handbook says we're also going to look at whether your employer was right and not treat its allegation as binding on us.
I think we may be speaking past each other, but I think I'm saying the same thing, that the finding of noncompliance, the determination is exactly what FAA did here. It investigated the circumstances around the reported refusal and determined whether those justified a finding that he could not use his airman certificate.
Right. And then just to clarify, but your position is nothing in here or anything else says that the FAA will revisit the employer's determination that there was a refusal to test.
No, that is one, the reported refusal is one factual input into the overall determination about whether to take legal enforcement action. And the court can posit any number of third-party factual information or report that the FAA or other government agencies use to trigger different requirements. And nothing about that presents a non-delegation problem.
But under
Just one.
49 USC, the 44702D, FAA on its own determination can reconsider any action by the private entity, right?
I'm so sorry, I
They
couldn't
can
hear you.
reconsider any action by the private entity under the 49 USC 44702D.
I'm sorry, I'm not sure which regulation your honor is referring to.
So it's the statute, and it's very curious that no one has cited this, but 44702D, I'm sorry,
Yes.
Judge Child,
Yes.
but it says, subject to supervision and review, the administrator may delegate to a qualified private person the examination, testing, and inspection necessary to issue a certificate under this chapter. And then subparagraph 3 says a person affected by an action of a private person may apply for reconsideration of the action by the administrator. That sure sounds like, yes, you can delegate something like this to a private employer, but if a person affected asks you to reconsider, the administrator has to do so.
Yeah, I'm not sure
Why
that.
doesn't that describe this case? Or I know maybe you are not familiar at the.
Yeah, I'm not sure that we've looked at that statute or briefed it, but be happy to provide supplemental briefing on the application of that subsection to this case. There are, as your honor is familiar, there are private parties involved in many aspects of the drug testing and enforcement scheme. So, and none of those involve a private non-delegation problem. The employer can impose drug testing requirements, can report those results to FAA, and that doesn't delegate.
Mr. Paul is very concerned also, I'm sorry, about the database.
Yes, sir.
So we've talked about the return to duty requirement. This private employer determination also gets his name in this database.
That's right. Excuse me.
Why isn't that essentially, and that is a government run database that people have to check. Why isn't that the type of, governmental authority the private non-delegation doctrine is concerned with?
The reporting to a database.
Reporting to the database that then every future employer is required to access.
Well, your honor, because there's any number of information provided by third parties, housed in databases, and there's no private non-delegation problem when that information is housed in a database that can be consulted later.
If an individual complains that the test that he took was improperly conducted, does the FAA hear such complaints?
I think the way that for instance, a positive drug test, is that what a positive drug test would be reported in much the same way to the Drug Abatement Division, and they would evaluate the circumstances around the positive drug test as it did here.
You can challenge the results of a test conducted by the employer.
Your honor,
Are there cases on that?
Your honor, the point of the drug testing is not to determine whether it is not for some sort of governmental determination about the results of a drug test. It is in furtherance of FAA's maintenance of standards for those who hold airman certificates.
Do you understand my question? My question is whether if an employer conducts a drug test.
Yes.
And it comes out positive.
Yes.
And the airman or the pilot says the drug test was improperly conducted.
Yes.
And does the FAA review that?
in much the same way it does here. And then it would
Well,
get
the way it did here, it didn't review whether there was a refusal or not.
yes, Your Honor, it reviewed the circumstances surrounding the refusal to determine whether to take action against its certificate. FAA is not in the business of conducting drug tests that is not the governmental action at issue. FAA determines whether airmen can continue to hold air certificates. So in that instance, FAA would make a determination about whether the circumstances surrounding the positive drug test warranted legal action against the certificates. If it decided to revoke the certificate because of the positive drug test, and the airman did not satisfy the FAA that, the drug test, the positive drug test, did not indicate that he was unsafe or unqualified to hold an airman certificate, the airman certificate could be revoked or suspended. And as you noted earlier, that action is reviewable by the NTSB.
And what do you consider the no enforcement action to be beneficial to him, as you all have indicated?
Because he still holds his airman certificate. And as soon as he completes the return to duty requirements, he can continue to fly.
And then do you see a distinction between incomplete drug testing process versus refusal to take test?
I'm sorry, Your Honor.
Do you see a distinction between an incomplete drug testing process versus refusal to take? Because it just sounds like there's some intentionality in refusal versus incomplete process.
I think the regulations would describe all of those as a refusal to test, and then that triggers the need to test under the supervision of a substance abuse professional and complete any required counseling. But the regulations define what is a refusal to test in those circumstances, and there are lots of different facts that can trigger a refusal to test that then requires follow-up.
And based on your arguments, you make it sound like, why are we here? All he needs to do is go take the test and all this is over?
That's right, Your Honor. If he completes the return to duty requirements, I think Judge Garcia asked earlier, and while it's not in the record, my understanding is return to duty can be completed, in an afternoon or a day. It could be longer if the substance abuse professional determines that there is a problem that needs additional counseling or follow-up.
So I don't know if that could happen, but when I read the regulations, they're quite detailed. You go meet with somebody, they come up with a treatment plan. You meet again and again and again, and then you have to get their sign off. So from one perspective, that's kind of compounding the non-delegation problem. You already had one private entity, and now you're subject to the unreviewable discretion of another private person about when you get to fly a plane again. If it always took maybe there's a de minimis exception to private non-delegation if it just takes an afternoon, but we don't really have a record about that, do we? About how long this return to duty process?
No, Your Honor, and there is nothing in the record about the return to duty process because Mr. Paul hasn't completed it.
How would he do that? So normally the employer finds the SAP, but this employer used this as an excuse to fire him right away.
And gave him information.
So who does he go? You go to an independent SAP.
I believe in this instance, he was given information about a substance abuse professional so he has that information available. But yes, Your Honor, from our perspective, the only enforcement action possible against him was taken. It was rendered in his favor. And all he needs to do is complete the return to duty requirements, which are just of a piece with the random drug testing requirements and other requirements to perform safety sensitive functions. And those make sense before we're allowed.
It's not just taking the test. It's all this other stuff.
Well, the return to duty requirements may be as simple as meeting with a substance abuse professional and explaining the circumstances and proving that you're safe to fly. They could be longer if the substance abuse professional determines that they need to do additional steps before resuming safety sensitive functions. But in the same way that FAA sensibly requires random drug testing, it requires this follow-up step.
All right, thank you.
No further questions. We ask that the petition for review be denied.
We've allotted you 2 minutes for rebuttal.
Thank you, Your Honors. I will keep this very brief. First, just to confirm, Mr. Paul was not interviewed as part of the FAA's investigation of the report. Secondly, I do want to clarify that even when a pilot does
Did he
complete.
file a brief or a memorandum or anything?
Did he file, pardon me?
Did he file anything?
He, Mr. Paul, both through his own counsel early in the process, after he received his letter of investigation, did submit a letter to the FAA, and then subsequently in June of last year, submitted a separate letter under his own signature.
Okay.
And I also additionally just wanted to clarify that even when a pilot does complete the return to duty process, and it's our understanding that that Mr. Paul had completed that at sometime during last year, and we are happy to provide supplemental information to the court if you're interested to verify that. But even with that, he still cannot hold a first-class medical certificate because a drug test refusal is regarded as a substance abuse problem. And so under 14 CFR 67-107B2, he can't hold this for 2 years. So it's not simply a matter of, complete the return to duty process and you're back to work. It's far from it. He's got a 2-year, time horizon between
There's no citation for this, but on page 30 of the FAA's brief, they say, if you just go ahead and apply for a new medical certificate, in that context, he can contest the employer's report of a refusal. Do you understand that to be correct?
I understand that if he was seeking a special issuance, that he might be able to raise, issues regarding the test report. I think that doesn't necessarily, of course, the timeline for a special issuance is very indeterminate. It could be short. It could be probably much more likely a fairly lengthy period. And that still does not resolve the issue of the permanent black mark on his record in the pilot records database. And I think that is, I think that concludes my rebuttal, unless the court has any further questions for me. Thank you.
So much. Both cases are submitted.
Stand, please. It is honored or not to stand during the floor. Training for your